Good morning. I've got 10 o'clock, and we're going to go ahead and get the webinar started. This is Victoria Beal with the Ohio LTAP Center, and we are attempting to record the webinar, so hopefully the recording will work and we'll be able to post that at a later date and send you a link to it. But I encourage you to please ask questions during the webinar, either via the chat pod or by unmuting your phone line. Otherwise, during the webinar, please do keep your phone line muted to cut down on the background noise for the presenter. So without further ado, I'm going to go ahead and turn it over to Sean Hillman from our Office of Real Estate. Thanks. Sean?
Thank you, Victoria. Good morning, everybody. Thank you for joining us. This is...
Are you there?
I am here.
Oh, dear. Sounds like somebody.
Yeah, can you hear me?
I can hear you.
Okay.
All right. Are you ready?
Thanks, Victoria.
Okay.
This is Sean Hillman. I'm the statewide LPA coordinator with the Office of Real Estate. Today we're going to present...
Your volume seemed to go down there. If you could just get closer to the speaker.
Is that better?
That's definitely better.
All right. Today we'll be presenting the first of what may turn into a series of webinars on different subjects and disciplines within the real estate acquisition functions. Today we'll be talking about the waiver of appraisal, also commonly known as the value analysis. What we hope to cover today, amongst other things, is what exactly the waiver of appraisal is, how and why it was developed, and the various advantages of using the waiver of appraisal, and we'll also talk about how you can get pre-qualified to perform the waiver of appraisal function. Right now, more than 65% of ODOT's program, the parcels that we acquire in our program, utilize the waiver of appraisal, and just by the nature of the LPA projects, they're smaller scale in general. There's even more use in the LPA program. So we want to make the LPA community aware of what it is and why and how it can be used and how it can be used efficiently to help deliver projects faster and cheaper. Doug Maitland is the manager of our acquisition services section, which includes the appraisal unit, and Doug will be doing the presentation today. So with that, I'll turn it over to Doug. Take it away, sir.
Thank you, John. This is Doug Maitland, manager of the acquisition services section. Today we're going to talk about the waiver of appraisal. So let's get going. All right, here's a succinct explanation of the right-of-way process. The reason we're going to talk about this is we have to interrelate the waiver's role in the process to acquire right-of-way. So when rights-of-way are needed for a highway project, the owner of the property needed for the project is offered compensation. That's also known as FMVE. That's an acronym for Fair Market Value Estimate. So then there's negotiations. Once agreement on price is obtained, the owner is paid compensation. The owner signs the instrument. The acquiring agency obtains control of the property needed for the project. And if agreement can't be reached, the agency exercises its right of eminent domain by filing an appropriation action and depositing FMVE with the court. Compensation is based on an appraisal process. At ODOT, this is known as the FMVE delivery process, and these are procedures that are in our appraisal manual. Parcel impact notes are created. These parcel impact notes are going to describe the valuation problem caused by the taking, and based on that problem, it's going to recommend the valuation format to be used to estimate compensation. And that could be the right-of-way appraisal report, which is a before and after narrative. It could be the value finding report, which is also an appraisal, but of simplistic issues, or the value analysis, which is the format we use when we exercise the right or the waiver of appraisal provision. Once we recommend the valuation format, the appraiser's engaged. The appraiser will create a written appraisal report. That report is reviewed by the review appraiser as required in 49 CFR. The reviewer is going to have three options. The reviewer can reject the appraisal report if it doesn't meet standards. The reviewer can accept the appraisal report, or the reviewer can recommend the appraisal report. What we prefer is when the reviewer is done with the review that they recommend the appraisal report as the basis to establish FMVE. The agency then will establish FMVE, also as required in 49 CFR, and an offer of compensation can now be made to the owner of the property. We use three valuation formats at ODOT. The first one, as we've already discussed, is the right-of-way appraisal report. It's a before and after narrative appraisal that prove or disprove the existence of damages to the residue property. It's USPAP compliant. USPAP is another acronym, Uniform Standards Professional Appraisal Process, and we offer the owner accompaniment, which is mandated by 49 CFR. These
Doug,
appraisals are
Victoria.
expensive.
Can I break in real quick here? I'm sorry. I just wanted to break in real quick and ask that everybody who has joined the webinar, please make sure your phone line's muted so that way we don't have background noise for the presenters while they're presenting. Thank you. Sorry about the interruption.
Not a problem. These right-of-way appraisal reports are very expensive and they're time-consuming. The next valuation format is the value finding report, also known as the VF. It is an appraisal of the whole that allocates to the part taken. Damages are not considered, so we don't require a before and after analysis. These appraisal reports are USPAP compliant, and the offer of owner accompaniment is mandated because it is an appraisal. Finally, there's the VA, the value analysis. It's the format we use when we exercise the waiver of appraisal provision. They're quick, they're simplistic, and they shouldn't be expensive to the agency. At ODOT, on average, the parcels that we acquire using the waiver of appraisal are about 65%. Lately, that percentage has been going up. Parcels acquired using the value finding format are 15%. So that's 80% of our overall acquisition parcels. Parcels that are acquired using the narrative before and after format are 20%. So it's pretty obvious that ODOT embraces and uses the waiver of appraisals for most of its acquisition parcels. So why was the waiver of appraisal developed? Before waivers were allowed, agencies could only use the narrative appraisal reports that valued the property in the before and after. Narrative appraisals require a valuation of the property before the taking and then a separate valuation of the residue after the taking to determine damages and an allocation to the part taken. These required skilled appraisers who are knowledgeable experts in eminent domain valuation. These narrative appraisal reports are large, 50 to 200 pages on average. They're time consuming, can be 4 to 8 weeks before these reports are delivered to the agency. And they're expensive, $5,000 to $15,000 on average, and we've paid much more than that. As their appraisals, a review of the narrative appraisals required, and that review itself can be expensive and time consuming. Cost of a review can range from $2,500 to $7,500 for these narrative appraisals. Time for a review is 4 to 6 weeks. The propensity to find problems create more time delays. And the negotiator, who's not an appraiser, is required to explain that report to the property owner, and the owners have difficulties understanding these before and after narrative appraisal reports. Narrative appraisal reports are certainly needed for complex valuation assignments, but these narrative style appraisals are overkill for simplistic, non-complicated valuation problems caused by small strip takes that represent the majority of acquisitions on our road projects. So budgets are tight, and it's a waste of taxpayer money pay for an expensive narrative appraisal report by credentialed appraisal experts to estimate compensation when trained non-credentialed staff people can estimate compensation that's not going to be significantly different. And these people can use simplified forms. They can follow explicit procedures. It'll be at a much reduced cost, $500 to $750 per waiver, and they'll be producing a compensation estimate in a matter of days and weeks at a faster clip than a narrative appraisal report. So that's why FHWA allows the use of waiver of appraisal. Waivers allow agencies to move faster at less cost. They estimate compensation that's not significantly different than before and after narrative appraisal reports. So what is a waiver of appraisal? It's permitted by laws and regulations. 49 CFR 24102 allows its use. Ohio Administrative Code allows its use. Ohio Revised Code, Section 16359, allows its use. This is in the eminent domain code section of our law for acquisition of properties under eminent domain, and Ohio Revised Code 16304, which is the notice of intent to acquire and good faith offer. So here is 49 CFR 24102. The federal code that allows waivers. The blue area that we've highlighted there drills in on the waiver. And it says, before negotiations, real property to be acquired shall be appraised except as provided in 24102. This is the section that allows waivers. An appraisal is not required if the agency determines an appraisal is unnecessary because the valuation problem is uncomplicated and the anticipated value of the proposed acquisition is estimated at $10,000 or less based on a review of available data. When an appraisal is determined unnecessary, the agency shall prepare a waiver valuation. The person performing the waiver must have sufficient understanding of the local real estate market to be qualified to make the waiver valuation. So based in these regulations, a condition for an agency to waive the appraisal are: agency has to determine valuation problem is uncomplicated, FMVE or compensation is estimated at $10,000 or less, and the preparer of the waiver must be qualified. So ODOT has implemented this regulation on a standardized form called the value analysis, also known as the VA. The VA is signed, it's dated, and it's retained in our acquisition files, and it's provided to the property owner at the time of the offer is made. ODOT's process requires an agency determination that the appraisal is unnecessary, that the valuation problem is uncomplicated, and compensation is less than $10,000, and all of this is done on a form we call parcel impact notes. ODOT requires a review of the VA by a review appraiser with a recommendation by the reviewer that the VA should be the basis of FMVE, and then ODOT requires an official from the agency to establish FMVE. All right, so what is an uncomplicated valuation problem? Well, first, it has to be obvious that the effect of the taking to the residue property causes no damages to the residue property. Because there's no damages to the residue property, there's no need to value the residue, so no before and after valuation is required. It also has to be obvious that the taking doesn't adversely affect the residue. This means the highest and best use doesn't change. Whatever the potential the property had before the taking, it has after the taking. Therefore, the taking or the acquisition creates a simplistic, uncomplicated valuation problem. 3, the highest and best use of the whole property has to be obvious. No analysis is required for a reasonable person to arrive at the same conclusion of highest and best use. It's obvious the highest and best use is the same as stated in the zoning code. Therefore, it's obvious that the estimated compensation from a full before and after narrative appraisal would not result in compensation being significantly different from that produced in a waiver of appraisal. It would be a waste of taxpayer money to do a full before and after analysis of the property to disprove the existence of damages or to determine the property's highest and best use. The waiver of appraisal process is only used for partial take acquisitions. There can be no buildings in the take area other than minor site improvements or old structures having no contributory value. So let's look at an example. Here's a piece of property, 330 foot wide, 1,320 feet deep, has 10 acres. That gray area is a driveway, and that green box represents the house. So got a house situated on a rural residential home site. Blue is the road, and we're going to have a 5-foot standard highway taking, typical strip take along the road on properties. We see this very often in our highway projects. So we have a 1,650 square foot highway easement. That's 5 foot wide by 330 foot long, and that contains 0.038 acres. So the 10-acre tract before the taking is reduced to 9.962 acres after the taking. The use of the property still looks like it's going to function as a single-family residential property. Doesn't look like there's any apparent damages. Land value in the area is going for about $8,000 an acre. And so a rough preliminary estimate of compensation is $304. $8,000 an acre times the area in that standard highway easement taking is $304. That compensation is less than $10,000. So the conclusion is the valuation problem is simplistic. There aren't apparent damages, and the estimated compensation is going to be less than $10,000. Therefore, the scope of work for this simplistic valuation problem is the value analysis. We can implement the waiver of appraisal provision that's in regulation. From a project management perspective, turnaround time for preparing and reviewing this VA should be short. Costs shouldn't be too expensive. We have a good chance of settling this parcel without filing an appropriation. So this is what the waiver allows us to do. We're going to look at another example. That blue area represents a commercial retail building. There's parking in front of the building. And this is the road that's on a corner lot. And on this example, there's a 25-foot WD taking. Obviously, this taking impacts the property more than the previous example. Let's assume that the property is zone GB, general business. The minimum site size is 14,000 square feet. Well, the site here is 120 by 140, therefore it contains 16,800 square feet. It exceeds the minimum size threshold under the zoning code. The take is 3,500 square feet, and that reduces the site to 13,300 square feet, which is less than the minimum square footage under the zoning code. So that presents some issues. The parking is reduced from 22 spaces to 11 spaces. Most people looking at this would say there's probably an apparent loss in value. Insufficient parking may affect the occupancy, may affect the type of tenant. All of that can affect the net operating income, which will reduce the value of the residue property. Non-conforming site size may affect the property's ability to expand and to rebuild, or if a tenant moves out, you may not be able to put another tenant in there because it no longer complies with the zoning code. Conclusion is the valuation problem's complex, damages are apparent, and so the scope of work for this complex valuation problem is going to be the right-of-way appraisal report. That a narrative appraisal is going to value the property before the taking and after the taking. From a project management perspective, turnaround time for preparing the appraisal and reviewing it will be several months. It's going to be expensive. We have an increased chance of appropriation, and we have a possible relocation of some occupants. All right, so that's talking about the complexity of the acquisition, an uncomplicated versus a complicated. So let's talk about acquisitions that are less than $10,000. In the state of Ohio, compensation can be for three things. The part taken, which is required under the Ohio Constitution, Article 1, Section 19. Damages to the part not taken, required in Ohio Eminent Domain Code. There's multiple citations in the code for that. And temporary easements needed for constructions, which is discussed in Ohio jury instruction. Add those three things together and we have estimated compensation. With a waiver of appraisal, we have to have an uncomplicated valuation problem that can't have damages to the residue. So therefore, if we take out damages, the $10,000 threshold for a waiver of appraisal is limited to the part taken and temporary easements. Valuation assumptions and processes for the waiver. Determine the whole property. Determine the highest and best use of the whole. Value the whole as a vacant site using the sales comparison approach. Ignore any improvements that are outside the take area. Determine the unit price of the whole, which is generally going to be a price per acre or a price per square foot. Allocate that unit price to the area taken. Add to this the value of any minor site improvements in the take area. And then add to that the estimated rental amount for any temporary easements. All right, so that talks about the $10,000 or less portion of the waiver of appraisal. So let's talk about the agency determines an appraisal as unnecessary. These are parcel impact notes, which is a form used by the Ohio Department of Transportation. This form has to be completed before the person does the appraisal or the value analysis. So we're going to discuss the valuation problem caused by the taking. That will go in this section of the form. We're going to conclude if the valuation problem is simplistic or uncomplicated or complex. That's going to go in this section of the form. We're then going to recommend the valuation format to use based on the valuation problems previously discussed in the form. And that's going to go in this section. And then those parties representing the agency have to sign off on the form agreeing that the problem is simplistic, that it looks to be going to be less than $10,000, and the VA is the right format to use. The review appraiser is going to sign off here. The agency official establishing FMVE would sign off here, and the appraiser who's going to prepare the VA would sign off here. Here is the value analysis form itself. What we've got here is a little case study that we're going to utilize to just fill in this form. On the case study, what we have is a 120-acre wooded recreational land tract that abuts a road, and we have a 5-foot wide WD take from that 120-acre tract of land. So 5 foot times 1,000 feet equals 5,000 square feet are in the take area. If we divide the take area by 43,560 square feet, which is the acreage in an acre, the take is 0.115 acres. So the WD taking is 0.115 acres. So that goes into this section of the form under parcel. The take area is 0.115 acres. The person who is preparing this VA has gone out, they have found comparable sales, and those sales indicate a unit value for the 120-acre tract of $7,500 an acre. There are no improvements in the take area. There's no remarks. So compensation is $863. So that's 0.115 acres times $7,500 an acre. is $862.50, rounded to $863. That's as simple as a VA should be. You have to fill out the owner's name, fill out the county route section. In the bottom, that pink area there is person who establishes FMV, or the person who prepared the VA signs there. The reviewer signs in the gray area. The blue area is where the agency official establishes FMVE. It shouldn't be too difficult. Here's the second page of the value analysis. There's that example again. The top of it in yellow is a brief sales history of the subject property, which would be the 120-acre tract. We identify the whole property at this section of the VA. We put in the zoning code if there is one. We put in the utility information. We put in what the apparent highest and best use of this property is. Now this next section, there's a bit of a sales grid here. And this is where the preparer would put in pertinent information about the comparable sales used, and then would also put in pertinent information about the reconciliation. In this case, it was $7,500 an acre, and any site improvements that would also be in the take area. No adjustments are required on that sale grid. So again, in this example, the preparer concluded that $7,500 an acre is the apparent unit value for the 120-acre whole property before the taking. We apply that $7,500 an acre to the take area, which is 0.115 acres, to get an estimated compensation amount of $863. The preparer would then summarize the effect on the take of the residue property. It has to be that there are no severance damages, because if there are apparent damages, this is the wrong form to use, and any other comments as applicable to this property could be inserted under other comments. All right, so the requirements for the value analysis. You've got to fill out pages 1 and 2 of the form. We need photographs of the subject. We cover these in our policies and procedures. Generally, it's going to be a street scene and a front view of the whole property, and then a view of the take area. We'll need attachments, which will be the sale data sheets, sales location map, the parcel impact notes, and a sketch of the property. The preparer has to physically inspect the subject property and the take area. The preparer does not have to offer the owner the right of accompaniment, because this is not an appraisal. This is a waiver of appraisal. Preparer has to be qualified. Consultants and LPA staff must be listed as approved to do the value analysis on the website for consultant services. So let's talk a little bit about becoming pre-qualified to do waivers. You go on to the consultant services website and get down to their booklet for the pre-approval qualifications for the different Office of Real Estate categories. You would look for the value analysis. And if you go to that page, this is what it's going to look like. 2.46 is the value analysis. So to be approved to do VAs for ODOT, you have to have basic appraisal knowledge, and you have to have knowledge of the VA procedures. You have to have an ability to read plans. You have to be a certified or licensed appraiser. And if you're not, then you must satisfactorily complete the following ODOT classes: highway plan reading, acquisition 101, which are laws, acquisition 102, valuation of simplistic acquisitions, and appraisal 105, appraisal review. The next page stops at after the number 2 there. And so the applicant has to provide a resume detailing work history, appraisal experience, experience with the value analysis, And if you haven't done an value analysis, if you look over at number 2 there, samples of value analysis or their equivalent that demonstrate your ability to estimate compensation using the waiver of appraisal valuation format. ODOT right-of-way courses that have been successfully completed, and samples of VAs, if you have any, demonstrating your competency. Your resume, along with this pertinent attachments, such as your course certificates or work samples, are going to be submitted to ODOT's Office of Consultant Services. They're going to refer this information to the Office of Real Estate, who's going to review the information that's been submitted. Office of Real Estate is going to then make a recommendation to the Office of Consultant Services, and it is the Office of Consultant Services who makes the determination if someone is added to the list. So that's how our process works. All right, so this is going to get a little deep here. This is the interrelationship between certified appraisers versus USPAP, Uniform Standards for Professional Appraisal Practice, versus the waiver of appraisal provision. So we have 3 intervening variables here. Certified appraisers are certified because they have appraisal licenses and certifications issued to them by the Ohio Department of Commerce. Certified appraisers have to comply with USPAP. That is a requirement of the Ohio Revised Code. There's your citation. USPAP governs the standards for appraisals in the United States. USPAP defines an appraisal as the act or process of developing an opinion of value or an opinion of value. That comes out of the latest edition of USPAP. The end product of a waiver valuation is an opinion of compensation. So our waivers meet the definition of appraisal under USPAP. So as the waiver is declared to be not an appraisal in 49 CFR and also in the Ohio Administrative Code, it doesn't comply with USPAP standards. There's an obvious conflict in law, regulation, and USPAP. The result of all of this that I've just gone over is that if we use a certified appraiser to prepare a waiver valuation, and that certified appraiser complies with our procedures, that certified appraiser is subject to disciplinary action by the Ohio Department of Commerce because they didn't comply with USPAP, and that's a violation of the Ohio Revised Code if they do a waiver for us. So if the appraiser adds whatever is necessary to the VA to turn it into an appraisal in an attempt to comply with USPAP, the agency is now going to have to comply with all the requirements for an appraisal, which is defeating the purpose of doing the waiver of appraisal. So it's a mess. And so to avoid this conundrum, what we've done is we've gone into the Ohio Administrative Code and we've worked with JCAR, and we have amended the Ohio Administrative Code. And this is the section that we've amended. When an appraisal is determined to be unnecessary, the agency shall prepare a waiver valuation. Persons preparing or reviewing the waiver valuation are precluded from complying with standards rules 1, 2, 3, and 4 of USPAP that are in effect as of the 2018-19 edition promulgated by the Appraisal Standards Board of the Appraisal Foundation. So what this means is that the language added into the Ohio Administrative Code is going to comply with the jurisdictional exception provision that's in USPAP. This addition to the Ohio Administrative Code precludes the person from preparing or reviewing a VA from complying with USPAP. So what the law is saying is you don't have to comply with USPAP. We're precluding the appraiser from doing that. Therefore, a certified appraiser only needs to invoke the jurisdictional exception rule in USPAP when preparing the VA, and the appraiser then won't be in violation of USPAP. Now, this webinar doesn't go into how to properly invoke jurisdictional exception. Anybody who's a certified appraiser will need to do that properly. All right, so let's talk about some frequently asked questions. Why does ODOT require the value analysis to be reviewed? Well, the requirement of review doesn't add significant time or cost. The review helps to assure that procedures have been followed, that compensation is reasonable, and it assists the agency's legal counsel to argue in an appropriation case that the agency has completed a proper valuation of the property. And here's another fact, frequently asked question. Can one person estimate compensation and also negotiate? Yes, so long as FMVE is $10,000 or less. That's a requirement in 49 CFR Part 24. Further, it's possible on a group of parcels having simplistic ownerships and valuations that the same person can do an abbreviated title report, that they can do the value analysis, that they can negotiate with the owner, and that they can also do the closing. And I accidentally hit the last key here. And
that's fine. We'll go ahead and open things up for questions. We appreciate the information very much. If you have questions, go ahead and put them in the chat pod, or feel free to unmute your phone line at this time and just ask them of the presenters. I can't imagine that there's no questions on this.
Boy, oh boy.
I don't know about that.
Well, you did an excellent job. Well, it looks like there's one question that came in. Why do we need appraisals on temporary construction easements?
All right, the answer to that question is say we only had a temporary easement that we were acquiring, that there were no other acquisitions. If we make an offer to acquire that temporary easement and the property owner says, no, I'm not selling under any condition, I'm not selling this, then we have the right to exercise our power of eminent domain and take that temporary. So the acquisition is under the power of eminent domain, which is section 163 of the revised code, and that requires we pay the owner compensation. Also, if we're using federal funds anywhere in the project, we have to pay the owner's compensation for what we take. So for that reason, we have to estimate compensation, and compensation is done through an appraisal process.
Thank you for the answer to that. While we're waiting to see if there's any other questions, just for the sake of our audience, I know you said that the person who's completing this form has to be, properly pre-qualified, and they don't have to be an appraiser. What types of positions have you seen in local public agencies that are not appraisers who have become pre-qualified in order to complete this process and save their agency potentially some money?
The majority of the folks,
if you're talking, get closer.
the folks that we've seen that are pre-qualified LPA staff are usually working with our larger, more urban LPAs, and they have in-house acquisition staff of some sort. Those that are dealing with right-of-way acquisition on a routine basis. But the idea here is that we want to make the LPAs aware that it really comes down to a project management and a program management. When you're seeing or soliciting consultants for cost proposals to do work on your projects, it's very common for consultants to use licensed appraisers to do valuations, waiver evaluations, or VAs on simplistic projects, because that's who they use all the time, or that happens to be who's available on their staff. And a lot of times that gets the cost of doing so, or cost of having somebody with that kind of education or that kind of licensure, that can get passed on to the client. So it wouldn't be uncommon to see prices for these VAs be higher because they're being done by a licensed appraiser when it's really not necessary. We wanted to point out and wanted to be clear that, you know, anybody on an LPA staff can go and get pre-qualified, and it's fairly easy to do so, to do these type of evaluations. It's just up to the LPA to make the determination on whether or not that's cost effective for them based on the size of the program and the amount of work they might have.
Great. Thank you for sharing that. We had another question that came into the chat pod. It says, on temporary easements, does the amount of time you need the easement have any impact on the amount that is paid to the owner?
Generally,
I think someone's trying to answer, but I'm not hearing them.
okay. On a temporary easement, we pay the rental amount, and the rental amount is going to be based on the duration of the temporary. Often they're 6 months to a year. So we estimate the unit value of the property, $7,500 an acre. We multiply that by the area encumbered by the temporary, and when we do that multiplication, that's going to give us the fee value of the land. We'll then multiply that by a capitalization rate appropriate for the land, 8%, 9%, 10%. It depends on the circumstances. That will give us the annualized income to the land, and then we multiply that by the duration of the temporary, and that's how we generally arrive at the rental amount for temporary construction easements. There are other ways, but that's typically what we see.
Okay. Looks like there's another question that's come in too. Why can't you use temporary easements for storage of materials?
Yeah, go ahead. You take that.
The temporary easements are written to be needed for the construction of the project. That's taken and is directly related to what is necessary for the contractor to complete the construction. If storage is needed, that is negotiated separately between a contractor and a property owner. But the plans do not call for storage areas. That's left up for the contractor to determine and to make accommodations for storage of materials. Temporary easements are to be for construction purposes only and for the construction of the project.
Great, thank you. I don't see any other questions in the chat pod right now. You can feel free to unmute your phone if you'd like to ask our presenters questions directly. There was a question concerning a copy of the presentation, and yes, we will send that out to everyone. We have also tried to record the presentation this morning, and if we are successful with that, we will send a link out to everyone of the recording. So I don't see any other questions coming in right now, and if we don't have anybody unmuting their line to ask a question, we'll just thank you both this morning for the wonderful presentation. Hopefully this presentation will help many of our LPAs to be able to move their acquisitions that are, meet those requirements through the process much quicker and save taxpayer dollars. So thank you so much for your time. All right, everyone have a good day.
Thank you.